Okay, well, Nikki lets the other person in. I'll go ahead.
You're on mute, Denise.
Good morning, everyone. I'm Denise Anderson Warren, and I'm the city clerk. Thank you for joining us. This is our onboarding for boards and commissions. I see some people that probably have been through this before, but it's always good to have the refresher. So today we'll be presenting to you some of the basics on the Brown Act, ethics, civility, and conflict of interest. Let me go over a couple of housekeeping items before I do the introductions. So first, let me ask everyone to mute your mics as well as your cameras. And when you go to speak, you can either raise your hands or you can put your questions in the chat section. And we will have a question answer at the end of each section. Okay, so presenting today, we have Assistant City Clerk Nakima Newsom. We have Jeremy Peterson from our IT department. And then we have Katie Dorr from our City Attorney's Office. She's our Deputy City Attorney 3. So now I'm going to turn it over to Jeremy to begin.
Thank you, Denise, and good morning, everyone. I'm just going to be going over a couple IT pieces for you, so going over our cybersecurity training requirements, as well as just some good knowledge to have related to using your city email. So as it relates to the cybersecurity training, you should have all received that already. If you haven't, you'll get an email after setting up your city email account asking you to complete your cybersecurity training within 48 hours. It's important to note as well that the city does do an annual cybersecurity training just to keep us safe and to make sure all of our technology is safe from outside attacks. So that happens every October. Given that we're in late September now, you might complete your training within 48 hours and then wonder why you get another training. And that's just because of the regular training that happens every October. The other thing that you'll want to just remember is the importance of using city emails. It's always important to do all of your official communications through your city email account, not only so that we're responding in a timely manner to the public in our roles and serving that as well, but also just to protect you. So as a public agency, we are under California's Public Records Act. So if for whatever reason a member of the community wants to put in a public records request to request information related to something that maybe you discussed at a meeting or been communicating about, you don't want them to have to go to your personal email in order to receive that information and reply to the request. So just a reminder to continue to use your city email. If you haven't gotten any information about that or having trouble set it up, first start with your department liaison. So who's ever overseeing the board or commission that you're serving on. Your department liaison is the person that helps you initially set that up and get you your account. If you run into any technical issues after that, or if you get locked out of your account because you haven't completed the cybersecurity training, we do have a 24/7 IT desk that's able to help you. And I'll throw the phone number into the chat right after this so that you can reach out to them directly. So that's all I have for you this morning, but I'll take a few seconds and pause if there's any questions.
There's a question in the chat from Natalia. Do all board and commissions members get official city emails or only certain ones?
Yeah, so all boards and commissions will receive an email, and you should get more information about that directly from your staff liaison.
Any other questions? Okay, seeing none.
I have a question.
Okay, go ahead.
How often do we need to take this training?
Yeah, so you'll take it the first time within 48 hours of setting up your account, and then
Right.
every October thereafter. So
Okay,
once a
thank
year.
you.
Yeah.
Thank you.
Great. Well, thank you all, and I will throw the phone number for the IT help desk if you ever need it directly in the chat for you.
Thank you, Jeremy. Much appreciated. Michelle, it looks like you just joined us, so I'm going to go over the housekeeping items with you. Can you please turn off your camera and your mic unless you have a question? You can either put it in the chat or you can raise your hand and we'll acknowledge you. Okay, so now I'm going to turn it over to Assistant City Clerk Nikema Newsom to begin the presentation.
All right, good morning, everybody. Thank you for joining us today. So the first thing I want to talk about is attendance and remote participation. So for commissions that meet monthly, members accumulating 2 unexcused absences over the course of 6 regular meetings will automatically vacate their membership on the commission. Members with 2 or more unexcused absences from any 6 consecutive meetings shall receive a warning. And if 2 more meetings are missed, the city clerk shall inform the city council. So if you know you're going to be absent from a meeting, just please make sure you make every effort to let your department liaison know in advance. Obviously, we know emergency situations happen and sometimes that you just can't do that. So in that case, if something does happen, an emergency and you can't reach out, just let your liaison know as soon as possible so that they can indicate that that was an excused absence. So as some of you may have started serving on boards and commissions at the end of last year, and so as you know, at that time, they were still all meeting virtually because under the governor's executive order during COVID, meetings were able to be held virtually. But since that sunset in March, members are now only able to attend meetings remotely under the rules of the Brown Act. So if a member wishes to attend a meeting telephonically, they should alert their staff liaison and the city clerk know as soon as possible to see if it's feasible to do so and to ensure all legal requirements are met. And that includes the agenda must specifically identify the teleconferencing location, the full address, room number, and the agenda must be posted at that location. And then we will need a photo to just show verified proof that the agenda is posted. Now, keep in mind, the agenda for a regular meeting must be posted within 72 hours before that meeting. So if your commission meets on Thursday, and that means your agenda needs to be posted by Monday. So if you find out Tuesday morning you need to be out of town, well, at that point it's too late to try to meet telephonically because it's outside the 72-hour window. In the event of a special meeting, you could do that because of the fact that special meeting agendas need to be posted within 24 hours. But in a case of a regular meeting, if you find out that you need to be out of town or something like that outside that window, it's probably not going to be possible. Now, I know in some instances you may feel like, well, who's really going to know I didn't post my agenda if I'm, out of the country in Mexico or whatever. It doesn't matter if it doesn't seem likely that someone would know. It needs to be posted. Katie actually told an interesting story the other day where someone was in Mexico and there was a union item on the agenda, and the union actually sent a representative to Mexico just to verify that they did follow the rules of the Brown Act. So you want to be careful with that. Each teleconference location must be accessible to the public, and members of the public must be able to address the body from the location. At least a quorum of members must be participating from locations within the boundaries of the city. So if you're going to be out of town and then there's another member that's going to be out of town and then they just say that they're absent, then your meeting would not be able to, if your member was a 5-body board, you wouldn't be able to continue the meeting because there wouldn't be a quorum present. And then all votes must be taken by roll call. So we, as the city, enacted a civility policy. It was adopted in December of 2011 to help ensure that civic engagement and local democracy continue to flourish and to safeguard participatory democracy in the city. There are 6 guidelines for behavior at all public meetings within the city. Number 1, treat everyone courteously. Number 2, listen to others respectfully. Number 3, exercise self-control. Number 4, give open-minded consideration to all viewpoints. Number 5, focus on the issues and avoid personalizing debate. And number 6, embrace respectful disagreement and dissent as democratic rights, inherent components of an inclusive public process, and tools for forging sound decisions. We do encourage that this is printed on the agendas for all your meetings, and that also that your chair or your vice chair reads it out to the public at every meeting. So some practical guidelines for practicing civility and respect. It's not simply being polite or keeping silent. It's about encouraging others' right to speak their mind in a professional and respectful manner. Before acting and speaking, consider the impact of your words on or actions on others. Rely on facts rather than assumptions, and then take some time to gather relevant facts before acting or committing to an action based on that assumption. Understand your triggers or hot buttons. Knowing what makes you angry or frustrated enables you to manage your reactions and respond in a more appropriate manner. Adopt a positive and solution-driven approach in resolving conflicts. And if someone is behaving in an uncivil manner, respectfully inform them that you want to hear them and understand their concerns, but that in order to continue with the conversation, you need to proceed in a civil and respectful manner. In regards to abusive conduct or bullying, abusive conduct goes beyond just mere incivility. State law defines abusive conduct as a person in the workplace who conducts themselves with malice that a reasonable person would find hostile, offensive, and unrelated to the city's legitimate business interest. And it includes verbal abuse, derogatory remarks, insults, epithets, threatening, intimidating, humiliating, physical or verbal conduct, or undermining a person's work performance. Some examples of abusive behavior or bullying behavior would be spreading misinformation or rumors, behavior, language, or gestures meant to patronize, frighten, humiliate, intimidate, or demean, including criticism or feedback delivered with yelling, direct or implicit threats, insults, or offensive language. Repeatedly demanding a person to perform tasks that are inconsistent with their job or outside their job responsibilities or authority, refusing to take no for an answer when the person is within their right to decline a demand, or pressuring a person to provide information that they do not have or are not authorized to release. Sabotaging or undermining a person's work performance, or circulating inappropriate or embarrassing photos, videos, or information via email, social media, or other means. Now we're going to dive into the sunshine laws, or the Ralph Brown Act. So all meetings of the legislative body of a local agency shall be open to the public, and all persons shall be permitted to attend any meeting of the legislative body of a local agency, except as otherwise provided. Public agencies exist to aid in the conduct of the people's business. It is the intent of the law that their actions be taken openly and that their deliberations be conducted openly. The people of this state do not yield their sovereignty to the agencies which serve them. The people in delegating authority do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. The people insist on remaining informed so that they may retain control over the instruments they have created. So as this applies to board and commission members, the Brown Act expressly provides that any person elected, appointed to serve as a member of a legislative body who has not yet assumed the duties of office shall conform his or her conduct to the requirements of this chapter and shall be treated for purposes of enforcement of this chapter as if he or she has already assumed office. So say, for example, the council appoints a member to the Disabilities Commission at the September 26th meeting, but the commission doesn't meet until October 15th. Even though that person has not attended a meeting, has not been sworn in, they are still considered a member of that body, and they should still conform to the rules of the Brown Act. Meetings, the Brown Act generally requires that a legislative body post an agenda at least 72 hours before a regular meeting that describes items to be discussed and prohibits any discussion or action on an item not listed on the posted agenda. Or a member of the public raises an issue that is not agendized, the legislative body may briefly ask clarifying questions and provide information to the public or provide direction to staff to place the item on a future agenda. The public can talk about anything, but a legislative body generally cannot act upon or discuss any item that is not on the agenda. So to attend a meeting, you cannot require any registration as a condition of attendance at that meeting. Now, we do ask, particularly members of the public who are requesting to speak, that they do sign in. That's not required. We simply ask that to just maintain meeting management as well as to help in drafting the minutes, but it's not a requirement. They have the right to record. They can use either an audio recorder or video recorder or still motion camera, unless that equipment somehow distracts or disturbs or disrupts the meeting with lights or noise or anything like that. And there can be no secret ballots, even if it's a preliminary vote. All votes must be taken out in the public's eyes. And with that, I will turn it over to City Clerk Denise Anderson Warren.
Thank you, Nikki. Are there any questions on this section so far? Okay, and I'll keep going. Okay, so now we're going to talk about public comment. What is required and what are reasonable rules? So required, every agenda for regular meetings shall provide an opportunity for members of the public to speak directly and address the legislative body. And that's on any items of interest that are on the agenda. During the legislative body's consideration of an item that is within the subject matter jurisdiction of the legislative body, provided that no action shall be taken on any item not appearing on the agenda, unless the action is otherwise authorized. Reasonable rules. So the legislative body of a local agency may adopt reasonable regulations to ensure that the intent is carried out, including but not limited to regulating the total amount of time allocated for public testimony. For individual speakers, I think those of you that are aware, our council meetings, we do have a limit on a total of 6 minutes that you can speak on a council meeting. And we break it down. You can speak for 1 minute or 2 minutes maximum. And then there's time donation, but it's basically 6 minutes a person has that they can address all items on the agenda. Next slide. Again, with public comment, a commission may not censor public comment. It may not refuse to publish written comments it deems inappropriate or mute the mic during the meetings. The Brown Act prohibits legislative bodies from enacting regulations prohibiting public criticism of policies, procedures, programs, or service of the agency, or acts or omits from the legislative body. So just remember that when people get up and they may criticize what decisions you guys are making, let them have their moment, let them have their minute or their 2 minutes, and they are entitled to that, so you can't cut them off. Hi, Natalia, you have a question?
Yes, so I put it in the chat, but I was just wondering, are written public comments on a body that's subject to the Brown Act required to be shared within a certain period of time, or is it just
No.
when it's available? Okay.
No, the written public comment, and Katie, you may want to jump in on here. Written public comment is not something that is required to be published. It's required to be part of the public record. So at the meeting, if you have public comments, that's to be included. If you have time to be able to upload it to what's online, you can. That's one of the council rules that they advise for us to do, but it's not something that is required. Is that
right,
accurate?
and I would add to that the written public comments would be subject to a Public Records Act request and would be disclosable under that as well.
Thank you.
Thank you for the clarification.
Disruptive comment. So I think Nikki covered that under civility. But if a commenter becomes disruptive, they may be removed after the presiding officer provides a warning to the disruptive individual, and failure to cease that behavior may result in removal. So that should be part of your rules as well. Next slide. Quasi-judicial hearings and fair practices. So some commissions, for example, the Planning Commission and Landmarks Commission, make decisions affecting specific parcels of projects that require findings based on facts. So to ensure the applicants receive due process, commissioners should only consider the facts before them at the hearing and should refrain from making any decisions or announcing their opinions before the matter is heard, and that's including all public comment. Commissioners should not attend community meetings about the project. At the beginning of the hearing, commissioners must disclose any outside communication or independent investigation about the project. To ensure the decision is based on factual evidence in the record and that findings are supported by substantial evidence. Next slide. Okay, so what constitutes a meeting? So it's when the majority of the members of a legislative body are meeting at the same time and location to hear, discuss, deliberate, or take action on any item that is within the subject matter jurisdiction of the legislative body. So meetings are not limited to face-to-face gatherings. They include communications by telephone, computer, smartphone, text, messaging, social media apps, and any other form of communication. Next slide. So now let's talk about prohibited serial meetings. So the Brown Act expressly prohibits a majority of the members of the legislative body from outside a meeting using a series of communications of any kind directly or through intermediaries to discuss, deliberate, or take action on any item of business that is within the subject matter jurisdiction of the legislative body. So there's a prohibition against serial meetings. So a series of communication where it each involves less than the majority of the legislative body, but can be taken as a whole, involve the majority of the body. So as a result, it deprives the public of the opportunity to meaningfully participate in the discussion. So now we'll kind of talk about the different types of serial meetings examples. So types of prohibited serial meetings. So there's a daisy chain and a hub and spoke. So a daisy chain is member A contacts member B contacts member C contacts member D, until a quorum of a collective concurrence and understanding of some kind has been reached. Now, the hub and spoke is, for example, a staff member or a legislative body member acts as the hub, and then they communicate with other members one by one to reach a decision. So these two types of examples are examples of prohibited serial meetings. Any questions on that? Nope. Okay, next slide. Now, AB 992 addresses serial meetings and social media. So the Brown Act, as you know, is a long-standing legislative, but since then we had social media. So this is the update. So serial meeting prohibition does not prevent a member of the legislative body from engaging in separate conversations or communications on an internet-based social media platform to answer questions, provide information to the public, or solicit information from the public regarding the matter that is within the subject matter jurisdiction of the legislative body, provided that a majority, go back, Nikki, provided that a majority of the members of the legislative body do not use the internet-based social media platform to discuss amongst themselves business of a specific nature that is within the subject matter jurisdiction of the body. Okay, so internet-based social media platforms, it applies to communications, online social media platforms that members of the general public have the ability to access, participate, it's free of charge, and without the approval of the social media platform or person or entity other than a social media platform, including any forms of chat rooms, and cannot be blocked from doing so. So that's what they consider internet-based social media platforms. Discuss among themselves means communications made, posted, or shared on an internet-based social media platform between members of a legislative body. So this includes using digital icons, expressions, reactions, or communications made by other members of the legislative body. So that would be the emojis, the thumbs up, the like, that sort of thing. And there's prohibition on direct responses. So a member of the legislative body shall not respond directly to any communication on an internet-based social media platform regarding a matter that is within the subject matter jurisdiction of the legislative body that's made, posted, or shared by other members of the body. Any questions on that? Nope, not seeing any. Okay. Okay, so there are some remedies and penalties if the Brown Act is violated. So there's criminal penalties for willful violations, civil relief to prevent or stop violations, and civil relief to void prior actions. Attorney fees and costs may be awarded in a civil proceeding for relief if it's not found that the legislative body violated the Brown Act. And on that, I'm now going to turn it over. Oh, no. Do I have one more? Okay. And Jeremy brought it up, but the Public Records Act. Members of the public have the right to inspect and receive copies of public records. Public records include all writings containing information related to the conduct of the public's business that are prepared, owned, used, and retained by city employees. Public records include records on personal devices, that's texts, smartphones, which is why it's so important for you to use the city's email for any city business. Requests are made and forwarded to my office, exemptions determined by the city attorney's office, and that would include attorney privilege, client privilege, certain law enforcement and personnel records. Sanctions, including awards of city attorney fees for violation of the Public Records Act, apply. And on that, I will now turn it over to Deputy City Attorney Katie Dorr.
Thank you. I'm going to share my version of the PowerPoint, so if you'll give me just a second. Okay. And then one thing I would note on the use of personal versus city email, if you receive an email that relates to your city business on your personal account or your personal device, forward it to your city account and then reply from there. And that's a good way to sort of correct the problem of receiving things on your personal accounts, because it'll then be searchable and it will put it into the system that way. So today I'm going to cover ethics. You're all required, now that you're city commissioners, public officials, to take the state required ethics training, which is commonly referred to as the AB 1234 training. Under state law, you have a year to complete that training, but under our city law, you're to complete that within 30 days. The FPPC provides the training available on its website. It's a free training, and it's a 2-hour training, and that presentation goes into much more detail than this presentation will go into today. Today, we'll just do a brief refresher and touch on a few things that are unique to Santa Monica. So in the year 2000, the people of Santa Monica voted to amend the city charter to include specific ethical guidelines beyond those required by state law. And this slide is an excerpt from that charter section. And as a public official, you have a duty to make decisions for the benefit of the public and not for your own personal gain. So these are the general ethical principles that should guide your service on a city board or commission. You should act for the public good, not for personal gain. Avoid actions that would cause the public to question whether government decisions are based on private interests rather than the public interest. Cultivate public trust in the government process. Support the public's right to know. Safeguard public resources, and treat every person with dignity and respect. In 2015, the City Council adopted a city code of ethics that applies to all city boards and commissions, and it's based on the guiding principles of fairness, integrity, transparency, and accountability. And these are principles that should guide all of your decisions as public officials. I'm not going to read this whole slide, but the code of ethics is available online on the city's website. Conflicts of interest. This slide shows the layers of ethical regulations throughout federal, state, and local law that regulate the actions of public officials. All of these are primarily based on the premise that you should not participate in a governmental decision in which you have a financial interest. And in most cases, officials do not violate these laws if you disclose your financial interest and abstain from participating in or seeking to influence a decision in which you may have an interest. Ethical rules can be complex. There's many exceptions that apply. So if you are in a situation where you think you may have a conflict, Say you're reviewing the agenda and you recognize some names on there, or say an employer or a source of income to you, reach out to your staff liaison or to the city attorney's office directly, and we can help you step through whether or not you have a conflict. And it's always better to talk to us sooner than later, because often these are highly fact-intensive analyses, and it's always better for us to give you the advice in advance rather than have you come up, say, after the item is called at your board or commission meeting and say, oh, no, I think I may have a conflict on this.
Katie, I'm just going to jump in. Margaret has a question.
Okay.
I just was wondering specifically, who do we talk to in the attorney's office?
You can contact me. I can put my email in the chat, or maybe Denise or Nikki could do that while I'm presenting. Or you can always, if you can't remember who to reach out to in the city attorney's office, you can always ask your staff liaison, can you connect me with somebody in the city attorney's office? And that may be even the better way to go about it, in case I'm not in the office or something at that point.
Jerry has a question next. Jerry, you want to unmute yourself?
How are you?
Good morning.
Good morning. I had a hard time getting on, but I got on about 20 minutes ago, and I had done the training a few weeks ago, the other training. I just wanted to ask a question. Naturally, I feel honored to have been appointed to the Urban Forest Task Force, and I'm just wondering what the ramifications are about just simple publicizing the annual tree hugging day event that we always have done for 12 years, the time, place, and location that we do to the general public and to all commissioners and city council and city staff, that if they'd like to attend. Is that subject to any legal thing, or can I just, say this is the tree hugging day event and where it's going to take place?
No, that would be fine. You can send, I don't know through what mechanism you do it, but
Facebook,
yeah,
a Facebook, thing, or an email, just to the usual people that have shown interest in coming.
Yeah, you can do you can post something on Facebook. You can do it via an email blast. The important thing to note is that people then that are on your commission or on other commissions should not respond to your post, consistent with what we discussed previously about social media interaction. But a one-way communication like that, whether it's through your commission or through the city's public information officers, that's fine. That would not be a violation.
Thank you very, very much. I appreciate it.
Other questions?
Yeah, it looks like we have a couple more. A second. Sorry, I'm trying to juggle. Edward Scott, you have a question? Edward, we can't hear you. Okay, we're going to skip over Edward for right now, and Michelle Edgar has a question.
Yes, hi there. I just have a quick question. If we do have a question we want to ask, like where can we submit it, or just, that might be time sensitive. That way we can just, be sure to ask if there's any uncertainty.
As far as if you have a conflict question?
Yes, just to know if it's something could be a conflict of not, like where could we submit it, just to make sure we are extra careful.
You can send it either to me directly. I put my email in the chat, or you can submit it through, you can talk to your staff liaison and they can connect you with our office. It's often good to keep your staff liaison in the loop anyway. You don't have to tell them the facts of your potential conflict, but you could say, hey, I'm looking into whether I may have a conflict on this item, just to give them the heads up.
All right, great. Thank you, Katie.
Anybody else?
Edward, are you able to speak now? Okay. I'm not able to. Okay. So Edgar's questions are, he put them in the chat. What are the rules for discussing matters before the board with other board members in advance of a meeting, as long as no decision is made? And 2, what happens if someone appearing before the board reaches out to a board member? Are we allowed to hear what they say?
Okay, so generally you should be careful about discussing items that will be before the board with your other commissioners to the extent that you don't want to talk to a quorum of your commission. So if somebody comes to you and says, hey, I want to talk about this, best practice is for you both to disclose who you may have already talked to on the commission to ensure that the discussion that you're having, plus the discussion that they may have had or you may have had with other commissioners, doesn't result in a quorum of your commission discussing an item outside of the public's view. So you have to be careful about discussing things outside of the public meeting. The second question, where did it go? What happens if someone appearing before a board reaches out to a board member? Are we allowed to hear what they have to say? Yeah, I don't think there's any restriction on that. You can, I'm sure as members of boards and commissions, you will receive emails, you'll receive public communication from the public, and yes, you can hear them out. Yes, on a 5-person commission, 3 would be a quorum. And on a 7-person commission, 4 is a quorum. Anything else for right now?
I think we got everybody for right now.
Okay. So honest services, bribery, and fraud. As you can see, and as I'm sure you're aware, there can be serious penalties for ethical violation.
Can't hear Katie.
Katie, it
Can
looks
you hear
like
me?
you're on mute. Yeah.
Oh, how long have I been on mute?
Probably about a
A
minute.
couple seconds.
Okay, I don't know how that happened. I didn't even touch my computer, but so anyway, don't commit bribery, don't commit fraud. It's also important to note that vote trading is illegal under the California Penal Code. So it's illegal for you to say, hey, other commissioner, I'll vote for your item if you agree to vote for my item next week. So don't do that either. Government Code Section 1090 and Charter Section 1302. Under Government Code Section 1090, a public official shall not be financially interested in any contract made by them in their official capacity or by any board or body or board of which they are members. The Attorney General has concluded that Section 1090 does apply to advisory bodies. The making of a contract includes all of the preliminary steps that go into its formation, including a recommendation from an advisory body to an ultimate decision maker. However, if a body is purely advisory, then the ultimate decision maker, which in most cases is city council, may still enter a contract so long as any financially interested member of the advisory body abstains from all discussions or decisions involving that contract. So for instance, if you're a landscape architect and you're sitting on the Parks Commission and the commission is making a recommendation on whether to enter a contract with your firm for construction of a new garden, the council would not be prohibited from contracting with your firm so long as you play absolutely no role in the Parks Commission's recommendation to the council. And the penalties for 1090 can be severe. Contracts that are entered in violation of 1090 can be void. There's fines and imprisonment, and also importantly, a prohibition against holding any public office in the future. The Political Reform Act. Under the Political Reform Act, an official has a financial interest in a decision if it is reasonably foreseeable that the decision will have a material financial effect different from that of the public generally on the official's economic interests. Financial interests can stem from business interests, investments, property interests, gifts, your spouse or your children's income, etc. So the main tenets of the Political Reform Act are: one, to disclose your financial interests, which is done via filing of Form 700 within 30 days of taking office, which many of you have probably already done. And two, to disqualify yourself if a decision would have a material effect on your financial interest. So what should you do if you do have a conflict that requires you to recuse? First, you may not participate in any way, not just in the vote, but in anything leading up to the vote, any discussions behind the scenes, absolutely no participation. And let other commissioners and your staff liaison know that you have a conflict and you can't talk about the item. And second, when the item is called during the meeting, state on the record that you have a conflict and what the basis of that conflict is, and then leave the room until the item is concluded. Revolving Door and the Oaks Initiative. So even though many of you are just now assuming office, there are ethical obligations that will continue even after your term is over. As a member of a city board or commission, you may not directly or indirectly negotiate future employment or future business opportunities with a person other than another governmental entity who has a matter pending before you or board of which you're a voting member. You're also prohibited from using your city position to influence a city decision involving the interests of a person with whom you have an agreement for future employment or business opportunities. And under the Santa Monica Oaks Initiative, if you vote to approve a contract or a land use approval, you then can't accept a personal or campaign advantage from that person or entity for a period of 2 years after you leave your public position. And there are similar provisions to the Oaks Initiative under state law. Common law conflicts of interest. While Section 1090 and the Political Reform Act are the primary state laws involving conflicts, there's also this sort of amorphous body of common sense, common law, conflict, or bias. So even if you can't pinpoint something under the Political Reform Act or Section 1090 that would prohibit your participation, if you find yourself in a position where, due to your personal interests, you feel you can't act objectively in the public's best interests, then you have a duty to recuse yourself. Gifts and perks. Be aware that as a public official, you may be required to report gifts that you receive, unless it falls into an exception, of which there are several. A gift is anything of value for which you don't provide payment or services of equal or greater value. And these rules are intended to reduce improper influence on public officials. Disclosure is required for gifts over $50 from a single source, and you must disqualify yourself on decisions involving a party from which you've received an aggregate of $590 in gifts or more in a calendar year. Your reporting obligation for gifts runs for 12 months prior to assuming your public position. There are, as I mentioned, some exceptions to the gift rules, which generally cover the most common sources of gifts, which is gifts unrelated to your public service or gifts received via social or family relationships. Gifts of that sort are not reportable. The FPPC has a lot of really good resources on their website regarding gift rules, and our office is also always available to help. City resources. It is unlawful for any state or local officer to use or permit others to use public resources for a campaign activity or for personal or other purposes which are not authorized by law. So the basic rule here is city resources should only be used for city business. This includes the use of city letterhead, use of your city email account, use of city copiers and computers, use of city employee time, use of conference rooms, that sort of thing. Use of the official seal of the city. You can't say, write a personal letter of recommendation for someone and put it on the city's letterhead with the city seal on it. And there are some de minimis exceptions, but keep this in mind as the general rule. AB 1234 training. If you haven't done your training yet, I recommend you do it as soon as you can. Here is the link to the free online training. And then again, if you have questions about conflict issues, you're always welcome to contact the city attorney's office directly or through your staff liaison. And we are happy to help. Does anybody have any other questions? How do I get a Form 700? I believe the clerk's office pushes out a link.
Yeah, I'll take that, Katie. So when you were first appointed to your board or commission, you should have received a welcome letter from the city clerk's office. And that letter would have indicated how you file your forms, your initial Form 700. We only accept it electronically, and there should have been a link in that letter. Sorry, what's the letter by? Yeah, it was sent by mail and email, but our liaison from our office is actually on the phone, on the call right now. His name is Xavier Moda. We'll have him reach out to you to make sure you get that information. So the next question.
Let's say there's another question. Is AB 1234 the only training required other than this training? Unless your board or commission somehow has another specific required training that they may require, the only trainings required by the state and the city are this training and AB 1234.
Looks like Jerry has a question.
Yes, and I did find the previous training very, very helpful. And I'd like to know what is any requirement or not for any of us to attend like a city council meeting or other commission meetings and speak on issues that are near and dear to our heart. Do we have to say we're speaking as an individual and not a member of the task force or commission that we're part of? Or is it assumed that unless we say we are representing them, can we just continue to be active and go to meetings and speak on various issues? And the other question is, I guess I'm assuming I'm not on the Urban Forest Task Force until I'm sworn in, and that would be an honor. But again, the email, how does that work? And how do I just make sure it's only for Urban Forest Task Force and not personal? Do I just tell people to email me personally if they get it wrong? If they go onto the website, or is there a phone number? Do I give my phone number, or is there a city phone number also for commissioners and task force members for business or not? So that's my questions.
On your first question, yes, you're welcome to continue to be an engaged public citizen and attend city council meetings and talk on issues of which you have an interest. But you should not represent yourself as speaking on behalf of your commission unless your commission has specifically voted or taken action to authorize you to speak on behalf of your commission. You can mention that you're a member of the commission, but you shouldn't say, I am here on behalf of the Urban Forestry Task Force. If that makes sense. Your second question, I think, unless Nikki or Denise have an answer, that may be more of an answer for, or a question for your staff liaison. Other than the city email, I'm not aware of other resources that are given to commissioners as far as public interaction.
I was going to jump in here and I was going to say, Jerry, as far as if there's any questions, they should communicate with you through the city email. And if you have questions, then you would talk with and have a conversation with your staff liaison. If there's something that there's really not, I don't think there's a reason for people to talk to you if they have questions, unless you want to call them back. But everything should go through your city email, and anything that you aren't sure of, you want to have the conversation with your staff. I wouldn't have you referring people to your staff liaison. And Natalia, looked like you had a question.
Yes, I had a question on the common law conflict of interest. Is it like does it cover only actual conflicts of interest, or does it also cover potential appearance of conflict of interest? For example, like if a matter comes before your board and or commission that has to do closely with, the business or action or anything taken by like a spouse or partner, close friend, something like that. And if the board or commission member, decides, oh no, I think I have a conflict, but members of the public might potentially disagree. What are potential risks if that kind of conversation, discussion, and any potential decisions are made on that item?
So common law conflict is difficult because it's all based in case law. So there's various factual scenarios which over time courts have said, yes, this could result in a common law conflict. There's not the same degree of penalties as there are with, say, a statutory conflict under 1090 or the Political Reform Act. Really, you want to avoid common law conflict for the reasons that we discussed earlier, which is you want to be clear that what you're doing is in the interest of the public. It's not for personal gain. So if there's a situation in which you don't have a statutory conflict and you feel that you can act in an unbiased manner, it's okay to say on the record, hey, here are the facts as to why there may be this perception that I have a conflict. However, I don't have a conflict and I am able to assess the facts fairly and act in the public interest on this matter. So if you have a common law conflict question, it's important to talk to city attorney's office so that we can verify that, yes, it's not actually a statutory conflict, and we can help guide you on what steps you should take.
Thank you.
Looks like Margaret has a question.
Yeah, I just have one more question in regards to like the daisy chain. So previously I served on the ARB, and occasionally people that were coming before us would reach out to us for some feedback. So I was wondering, I don't know if that occurs on the new commission that I'm on, but if somebody who is going to come before us reached out to me and then also 3 other people, is that like a violation of the Brown Act?
So you're on ARB?
I was before. I'm not anymore, but that's
okay.
I'm just trying to provide an example of a question that I have. I don't know that happened before. But I just was curious if that was.
Yeah, a member of the public can serve as the hub in a hub and spoke. So if that member of the public, so you should be cautious in talking to anybody. If they reach out to you, you should ask, well, who else on my board have you already talked to?
Okay.
That's best practice. And the reason I asked if you're on ARB, I'm not sure what commission you're on now, but if you're on a commission that makes quasi-judicial decisions, you need to be especially careful about communicating with project applicants in advance of an item coming before your commission, if it's a quasi-judicial item, because those conversations would need to be disclosed on the record.
Yes.
When the items are.
We did.
Okay.
I served on that, but I don't think that example ever happened. I often tried not to speak to them, but but I was just curious because I hadn't it just occurred to me, that question while we were talking. I just want to make sure I fully understood it. So
Yeah,
thank you.
I suppose you could have an instance where you have a reporter who comes to you and says, well, I've talked to commissioners A, B, and C, and they're in favor of this item. Where do you stand on this item? And that would certainly be a Brown Act violation if you were to engage in that sort of discussion.
Okay, thank you. That's super helpful. Now I'm on the airport commission. I'm not on
Okay.
air. Yeah, thank you.
Edward, do you have a question?
Cannot hear me. Okay.
We can hear you.
Oh, you can. Okay, sorry. All right. So following, actually, I am on the ARB, and I had a question, I guess, about the daisy chain as well. So, you know, if as I understood from my previous question, if I am in touch with quorum, in my case would be 4, I guess. So if I'm in touch with a board member or 2 in advance, just sort of discussing general topics, not making decisions, that's allowed as long as I disclose it? That's the first question.
That's allowed. The kind of things that require disclosure are more along the lines of discussions you've had with applicants,
Okay.
independent investigation that you've done. Say you did your own independent site visit to walk the site. Those sorts of things where you have taken in factual evidence outside of the hearing. Those are the things that are disclosable.
Okay. I mean, just obviously because you're assessing the architecture, sometimes you do want to take a look at the building itself.
Right.
But I guess the other question is, when you're talking to board members, do you need to find out from them who they're talking to so you avoid any kind of a daisy chain? Or again, the matters being discussed are really,
Katie, Katie, can I jump in here for a second?
Sure.
Edward, just from my perspective as the clerk, you probably want to get together what you consider a Brown Act group, and it's not a quorum. So it would be you and 2 other members that you can have these safe conversations with. And you want to find out, you don't want it to be 3 more you don't want it to be 3 members. So if you can, and I mean, this is just suggestion for you, because I know council members do this, then it's safe because it's only the 3 of you, and then you guys don't go outside of what you consider your Brown Act group.
Yeah, I mean, I've served in an interim position, so I've been talking to folks, and it's only 2 at a time at most. Usually it's only 1, so I get that part. I guess the question is, then they might be talking to other people too, but as long as it's 2 and 2 and 2, it doesn't matter, I guess, or 3.
No, it does matter. It matters who they've talked to. So if you've got your 2 on your, say you're having a meeting in your office or wherever, or a phone call, it is important to know who they've talked to about the same item, because if they have also talked to 2 others, you could be building consensus behind the scenes.
Okay.
So what we always told our council members was, you can only count to 3, and once you have your 3, that's your 3.
Yeah.
And their contacts count towards your 3.
Okay, thanks.
Because the whole idea is that you should only be making these sorts of decisions and having these sorts of discussions in the public view. Anybody else?
Any other questions? Okay, before we go, Nikki, you wanted to make an announcement?
Yes, so we did record this, and we will be sending out the recording along with the slide deck within the next week or so. Actually, we are going to send 2 versions of the recording and 2 versions of the decks. On Monday, we actually did 1 training, and afterwards we decided to make some changes to it. So for the benefit of everybody, we're just going to give you both options. And the other thing too, sometimes questions come up in other sessions that aren't asked in this session. So that way you get the benefit of the answers to those questions. So that we will make sure that is sent out to you by next week.
Okay, any other questions before we end this? No? Okay, well, thank you all for joining us this morning. I see Is there someone getting ready to say? Okay. Okay. Thank you all. We'll send this recording now. And remember, if you have any questions, please contact your staff liaisons first or either reach out to our office and we will direct you wherever you need to go. So thank you all and have a good day.
Thank you, Denise.